of our Energy Bootcamp series, and this one's on bankruptcy and distressed assets. It's similar to the other and consistent with the other themes and topics we've had in the Bootcamp series. This is, although tailored and kind of directed for the energy industry, it's a topic that is across all industries, and I think a couple on the phone today have had experience probably over the last 10 to 20 years across different groups like airlines, auto, real estate, and other areas. So for today, before we get into the actual session, I want to introduce the presenters and do a little bit of housekeeping. So first off, again, my name is Jeff Atkin, a partner in the business group at Foley, and worked with the other two folks on the call here, Rich Bernard and Matt Riopel, for the past several years in the energy industry in particular, working with a number of companies, helping them buy assets that were distressed, or also just dealing with contractual parties who were either in a bankruptcy situation or otherwise trying to make sure they got paid. So with this group, the presenters, Rich is a partner in our New York office. He has a significant amount of expertise and experience in the bankruptcy group. He's kind of covered areas across various industries, as mentioned, and is very active in the energy group right now, helping a number of our clients. Matt is an associate in our San Diego office. He's been sort of backing up and really doing a lot of the legwork and fielding a lot of questions from clients in the same area. And so we'll get into the overview here in just a second. A couple little housekeeping items. This, today's session, as it was mentioned, it is being recorded. The participants are also eligible for one general CLE credit. For New York, New Jersey, and Kansas attendees, you'll need to apply for CLE and fill out, there's an attorney affirmation form that is on, if you look on the right side of your screen, there's a section titled Materials, and you can pull the form from there. There is also, for New York, there's a course code that we'll give out at the end of the session right before the Q&A, and you'll need to enter that course code for that credit. In mentioning the Q&A, there's a box at the bottom right of your screen, and you can enter Q&A or specific questions that you would like us to go over. We're going to do the presentation, leave a few minutes at the end where we'll field some of those questions. If we don't get to all the questions, feel free to email either any of us on the call, and we can get back to you after the conference as well. So with that, let's go to the overview section. Today, this is really, what we're intending for this session is to really be a how-to a how-to, as mentioned, really buy distressed assets or deal with a counterparty, or in some cases you may be the counterparty that's either looking at a situation where the party may become insolvent soon, or is in fact insolvent or in bankruptcy, and how to figure out how you can do that in really kind of two major areas. One, if you're selling something to that distressed party, how do we make sure we get paid? What legal concepts go around that we need to be careful? And number two, if we're buying from a party that's distressed, how do we make sure we get the assets cleanly, and that someone after that transaction is not going to come make a claim against us, or if they are, how can we be best protected? And this is an area what we've seen over the last couple of years in the energy group is an area where a lot of parties have misstepped, and it's an area where just with a little bit of proper and kind of precise legal planning and advice, you can really protect yourself and save millions of dollars. And it's also something that's not new and not being created. And I think Rich could probably get into a little more detail, and will, in some of these kind of scenarios, but it's an area that we've seen just over the last 10, 15 years, and gone through these exact same issues and legal concepts with the airline industry, with the auto industry, with real estate, and with others. And now in the energy industry, if you look in the last couple of years in solar, for example, with Solyndra causing a big stink in that, Satcon, one of the big suppliers in the space, several other panel suppliers who've recently filed bankruptcy or gone bankrupt, and to some of the developers and sponsors who are looking at that. And in some cases, it's even been the foreign parent company filing in a foreign jurisdiction, and then how does that impact the U.S. side? So for an overview, we're going to just cover some general bankruptcy background topics. Number two, we'll get into dealing with a bankrupt or distressed counterparty and some of the issues that relate to that. Number three, really dealing specifically with how to, doing distressed asset purchases and a couple unique concepts around that. And then, as I mentioned, we'll get into the Q&A. So with that, Rich, I want to turn it over to you, and you can lead us off.
Thanks, Jeff, and thanks everybody for attending. I'm going to go through the background of bankruptcy very quickly. We have a lot of stuff in our materials covering it, but we're just going to hit on the high points on this first section and leave us a decent amount of time to cover the second and third topic areas. So initially, there are about 6 major types of bankruptcies. Generally, you're going to be dealing with Chapter 11 for a business entity that files bankruptcy. Chapter 11 can be used for reorganization or liquidation, and so it's very flexible in that way, but it is also very expensive. Chapter 7 is just a pure liquidation where a trustee gets appointed to gather up the assets, liquidate them, and pay creditors. In a Chapter 7, the trustee is not authorized under the code to operate the business, but can get operational authority from the court if preserving ongoing business operations can add value to the assets. Chapter 9 deals with municipalities. In the energy sector, you may come across some Chapter 9 issues. It's nothing like Chapter 11, and it's very different. And one of the major fights is whether the municipality actually has authority to file and has to hop through 4 major hurdles to commence a case. Chapter 12 applies to family farmers. 13 is an individual personal debt repayment plan, and Chapter 15 applies to cross-border cases where there's a foreign main proceeding and U.S. assets to administer or protect, and the trustee or administrator in the foreign proceeding would commence the Chapter 15. Just by way of background, the parties in a bankruptcy, you have your debtor or debtor in possession. That's the party commencing the bankruptcy. Debtor in possession is how we refer to the debtor in a Chapter 11 because the statutes allow for that party to remain in control and manage its assets. A trustee in the bankruptcy sense, generally we're talking about Chapter 7 trustees or panel. Those are panel trustees. There are trustees in Chapter 13 cases and appointed trustees in potentially in Chapter 11 cases under certain extreme circumstances. The United States trustee is the government. It's part of the Department of Justice, and it's the government oversight over the bankruptcy process. Usually they take positions early on in cases to protect creditors and then monitor mostly our professional fee applications. And then finally you have official committees. The Bankruptcy Code authorizes the appointment of committees, and most of the time you'll see unsecured creditors committees, but there are others. There may be subgroups of creditors that may petition and have a committee formed. Same thing with equity holders if it looks like the value of the enterprise is sufficient enough that there may be a distribution to equity. There are cases can be commenced voluntarily by the debtor or involuntarily by creditors. Once a case is voluntarily filed, an order for relief is automatically issued. and that's by operation of law. We'll get into the automatic stay in a little bit. In an involuntary case, there are a number of issues involved with respect to creditors not subject to a bona fide dispute that can commence a case for the company. The debtor has the ability to contest an involuntary petition, and it becomes a mini trial. I think there's a 21 days to respond to an involuntary petition. If the debtor doesn't respond or consents, then the court will issue the order for relief, starting the case. In an involuntary case, just like a voluntary case, the automatic stay kicks into effect on the petition date, regardless when or if the order for relief is entered.
Rich, quick question on that. We see in the contracts and kind of across the board where oftentimes a bankruptcy triggers an event of default, and they distinguish, we distinguish typically between an involuntary and a voluntary filing, and a lot of times there's a negotiation that if a company's put into involuntary bankruptcy, it doesn't trigger a default, or you have 90 days or something to get out of that before it triggers a default. So I guess two questions. One, what's a normal timeline, or is there one, for kind of getting out of an involuntary if you're a debtor? And then number two, does that really, if there's an automatic stay, does that stay a default under those contracts as well?
Yes. Well, let's start with the timeline. So the debtor has 21 days to respond to an involuntary proceeding. My first involuntary that I was ever involved in, the contest on whether the filing was proper went on for about 5 years, and 3 or 4 different appeals all the way up through the First Circuit. So they can be prolonged and protracted. I think that case really, I guess, set my understanding on how sour an involuntary could get if contested and hotly contested. Generally speaking, and we just filed an involuntary at the end of last year for a company, and it took about 60 days to get the order issued, issuing out the order for relief, and that the involuntary filing was proper. That's more or less your time frame. Generally, there'll be a response time frame. Usually the debtor doesn't expedite that by filing before the 21 days comes up. There's usually an initial hearing where issues are discussed, and a timeline for expedited discovery is either agreed to, or the court directs you to come to an agreement on that. Okay. Generally, you can push your discovery and get it done within 30 to 45 days, and then you would have an evidentiary hearing, sort of a mini trial in front of the bankruptcy judge on the issues. And as I said, I think we filed the case last November, and by mid-January, towards the end of January, we had an order entered on that. So okay. I think that's a more typical time frame. And
so
the second part,
practical advice for those provisions in contracts then. I mean, you'd want at least 60 days to be able to get out of a bankruptcy or an involuntary bankruptcy, probably more like 90 plus, but okay. And then, and then the second part, right. Does that really matter?
Well, there is an automatic stay in effect, and also such a provision is probably falls into it. It depends on the type of contract in a lot of cases, but it likely falls into what we call an ipso facto provision, which means that the debtor can assume the contract regardless of the bankruptcy default, and does not have to cure the bankruptcy default in order to assume the contract. So it basically takes the teeth out of bankruptcy filing as an event of default or that type of thing. However, in a loan agreement, you can't force a party to make you a loan even in bankruptcy, and so it does have teeth as far as if it's some sort of note or loan agreement, or an agreement to extend credit. The second part,
So,
the second part,
practical advice for those provisions in contracts then. I mean, you want at least 60 days to be able to get out of a bankruptcy or an involuntary bankruptcy, probably more like 90 plus, but okay. And then, the second part, does that really matter?
Well, The biggest, and this gets to your second point, the automatic stay is probably one of the biggest reasons that a company files bankruptcy. It gives the company a breathing spell. It's like an injunction worldwide against any of the assets of the debtor wherever located. The reality is assets outside the U.S., good luck trying to enforce or protect them with the U.S. bankruptcy code. But for at least for assets in the U.S. and parties in the U.S., this automatic stay has a lot of teeth to it, and it prevents creditors from taking action against the debtor or the debtor's assets. There are explicit exceptions, and the list is very numerous. Generally, they relate to health and safety, government enforcing certain laws for health and safety purposes. So we do have exceptions. Those exceptions actually were extended a little bit in 2005 with the last revision of the bankruptcy code, and in some of those extensions, it's difficult to know when the exception actually may kick in. There's one exception for serial filing. So if you have a counterparty that's constantly jumping into bankruptcy and getting kicked out of bankruptcy, I think it's the third time's a charm type of thing that they actually do not have an automatic stay. However, there's no order that says that, so generally you want to be safe and make sure that you're not in violation of a stay, because a party that violates a stay may be subject to damages or penalties entered by the bankruptcy court. So you need to be very careful with the automatic stay. Now, I mean, there are cases out there that say issuing a demand letter on a debtor after the debtor files bankruptcy is a violation of the automatic stay. Interesting, though, and we'll get into it a little bit in the next section, a reclamation claim is generally not considered a violation of the automatic stay, but there are particular provisions in the bankruptcy code that tell you how a reclamation claim is dealt with in bankruptcy. And for those of you who don't know, if you sell goods to a party under the UCC and under the bankruptcy code, if that party goes into bankruptcy, or if you have reason to believe under the UCC that the debtor has no intent to pay for those goods, within a window prescribed in each, and the windows are different time frames, you can issue a letter and say, give me my goods back, segregate them, and give them back to me. And if the counterparty has those goods still in their possession, they're required to do that under the Uniform Commercial Code. The Bankruptcy Code has its own provisions, and we'll circle around back to that in how we deal with it. All right, so now we're into our second topic, which is dealing with the distressed counterparty. And our first two issues sort of deal with what types of claims that you as a creditor may have, and what kind of rights you have under those claims against a debtor counterparty. Then we get into what sort of clawback rights the debtor has against creditors, and then finally, and probably most importantly to you, we get into executory contracts with a bankrupt counterparty and administrative claims. And so we'll start off with claims that arose before the bankruptcy case against a company that filed bankruptcy. First, you have set-off, and set-off is recognized in the Bankruptcy Code. And really what set-off does, it allows you to net cross-claims against the debtor. You cannot effectuate a set-off without stay relief, and there's requirements under the Bankruptcy Code when set-off applies. But generally, these are just cross-claims, and they get netted. Recoupment is a similar theory. It's not provided for in the Bankruptcy Code. It's old-time common law inequity. It allows for netting, and what makes recoupment unique is that it's cross-claims that arise from the same transaction or occurrence. And that's important because set-off can arise in the same transaction or occurrence. However, not all recoupments would constitute set-offs, and recoupments are even a more powerful tool than set-offs. So initially, the requirements for a set-off is that there's a debt owed by the creditor to the debtor, which arose pre-petition. And pre-petition, we're referring to the petition date. That's the document the debtor files in order to commence the bankruptcy case. And so you'll hear us use words like pre-petition and post-petition. That just refers to when the bankruptcy started. So the debt owed by the creditor arose before the bankruptcy. The claim that the debtor has against the creditor also arose before the bankruptcy, and they are mutual obligations. So it's the same parties. It's not a subsidiary of the debtor that has a claim against the creditor and the creditor has a claim against the debtor. That would not satisfy your mutuality requirements for party capacity. And the example we have here is a debt owed by a partner versus a partnership claim against the creditor. So if the parties are in different capacities, you're not going to get the benefit of set-off under the bankruptcy code. So I already mentioned that the automatic stay prevents the effectuation of a set-off right. However, if a bank may freeze a debtor's bank account under set-off theory, not indefinitely, it'll have to act sooner or later, preferably sooner under the case law, but can freeze that account and deny the debtor access if that debtor owes the bank money. Then we move on to that set-offs can be valid defenses for turnover action. So if the debtor is requiring you to turn over some assets that you're holding for the debtor, if you have a set-off claim, it's a valid defense for the turnover. And I have a note here on the cross obligations have to be mutual both in time. They both have to arise pre-petition or post-petition, but they have to be mutual in time and mutual against the same party. And also, finally, there are limitations in the bankruptcy code prohibiting or against creditors acquiring claims against the debtor for use for the purpose of set-off. So you can't just go out there and buy up claims on the cheap in order to effectuate a set-off or reduction in your obligation to the debtor. The code has certain prohibitions on that. Now we're going to get into recoupment, which is a lot like set-off. However, the important distinguishing characteristic is that it arises out of the same transaction. Now, recoupment can be effectuated. It doesn't require the mutuality of time. The one claim can arise pre-petition, the other claim can arise post-petition, and recoupment can, it's not a requirement, but a lot of times you'll see recoupment issues arise under an agreement of some sort. And just thinking that the most, I guess, popular, frequent time we see recoupment applied is in the Medicare, Medicaid context. So a healthcare provider will constantly submit requests for payment of healthcare claims from Medicare and Medicaid. That agreement allows for Medicare and Medicaid to recoup any overpayments from any future requests for payments. So and that can be effectuated regardless of a bankruptcy, and so it makes it very difficult for healthcare providers that have that owe Medicare and Medicaid significant sums to really have to derive benefit from a bankruptcy. because you don't get the benefit of the automatic stay when you're dealing with recoupment. Moving on to reclamation claims. Reclamation claims are apply to vendors who sell goods. So if you sell goods to a debtor or to a company and that company files bankruptcy, you're able to actually make a reclamation claim up to 45 days prior to the bankruptcy. If you're just dealing with a distressed entity, the Uniform Commercial Code has separate reclamation rights as well, and a different time frame on when you have to make the demand and how far back you can look once you make your demand. Specifically in the Bankruptcy Code, though, we have new provisions that deal with, or relatively new provisions that deal with reclamation claims. So, and those claims for the delivery of goods. Specifically, we now, since 2005, if you've delivered goods within to a debtor within 20 days of its filing a bankruptcy, you're immediately, or you're entitled to an administrative claim. The timing of payment of that claim is may not be immediate. It may be when the debtor emerges from bankruptcy and a plan goes effective, but it's entitled to the higher priority of as an administrative claim rather than a pre-petition claim. In addition, from day 21 to day 45, if the debtor's still holding goods, you may have rights to require the debtor to segregate those goods and return them to you. However, you know, we see a lot of secured lenders with blanket liens, and those blanket liens will trump a reclamation claim if they're underwater, and so you know, it's more difficult to recapture good value for goods delivered to the debtor. And I use that word delivered intentionally. That's part of the statute. It's the timing on the actual delivery of the goods when the debtor gets it that's relevant to these particular reclamation statutes. I'm going to turn over to Matt because I'm sure you're tired of hearing me drone on, but I'm going to turn over to Matt to deal with the clawback claims. Matt?
Thanks, Rich. Yeah, one of the most common calls that I get is from someone who's either dealing with a counterparty to a contract who they believe to be on the verge of bankruptcy, or who has filed bankruptcy and suddenly there's a demand letter from a lawyer asking for a repayment of money. Most typically this is a preference action, and what a preference action is if you receive money from a bankrupt entity within 90 days of the filing of the bankruptcy, and that was received on account of an old debt, or just any debt really that was owing at the time the payment was received, you can be obligated to repay that payment to the estate. And typically what will happen in a bankruptcy case is that a report will be pulled. Every payment within 90 days will be tabulated, and every payment over X dollars, sometimes as low as $10,000, usually closer to about a $20,000 floor, a letter will go out demanding repayment, and most people don't know how to react. Some people throw the letters away, some make payments quickly, others reach out to us or other lawyers to negotiate some sort of a settlement.
And Matt,
sure.
I was going to ask you if a client calls you and says, "Hey, Joe Blow is in financial trouble, but they're offering to pay me the $1 million that they owed me from last year. Should I take the money?" What's your common response?
Yeah, you read my mind, and it's always take the money. Take the money every time, because there's nothing wrong with accepting a preferential transfer. It doesn't mean you did anything illegal, you didn't commit a fraud, you haven't violated any law. The whole purpose of a preference action is equal treatment of creditors. And you could just as likely get the payment 91 days before they're able to file a bankruptcy as on the 90th day. So always take the money. cash it as quickly as you can. If you can get a wire or some other method of getting the money sooner, make sure to do it. But definitely, if you think your counterparty is on the verge, don't sit on any checks. Get them to the bank as quickly as possible, and always take the money.
Yeah, there's no requirement that the debtor bring preference actions to claw back funds and redistribute them to all creditors more evenly. And a lot of times in a normal type of Chapter 11 restructuring, where you have NewCo emerging, NewCo doesn't want to disrupt its relationship with its suppliers and vendors and counterparties, and so those actions may never be brought. Conversely, and what we're seeing a lot more now, we'll discuss it a little later, in the 363 sale context in a bankruptcy, a lot of times unsecured creditors are getting very little, and nowadays we're seeing a lot more creditor trust created through a plan and the assignment of these clawback rights to the trust for prosecution. So there is, unless the buyer protects the vendors and counterparties from the clawback rights, and honestly, the 363 sale, one of the assets the buyer can buy is rights or clawback rights against various parties, and a lot of times they do. If they don't, then there may be a risk of exposure, but that exposure is 2 years down the road under the statute of limitations. And so even if you have exposure for this redistribution statute, you may be able to negotiate to keep a good majority of that money, number one, if the action is even brought, and number two, you get the use of those funds over that time before an action is even commenced. So again, if offered to take the money, and then we can deal with the subsequent issues.
And there are a number of defenses to preference actions. In our standard operating procedure, if one of our clients gets a preference defense letter, is to get a basic understanding of the history of the business between the client and the debtor, and prepare usually a fairly detailed letter response. And typically, you're dealing with a trustee. Typically, you're able to reduce the amount of exposure very quickly. It depends on the facts, but recently I've settled preference actions of excess of $600,000 for less than 20. So it's really about finding the right defenses, asserting them clearly, and making the trustee realize that you're not just going to roll over and that you don't want to, that they don't want to spend the money coming after you. So the three primary defenses are contemporaneous exchange for value. If you're on COD, you have really no preference exposure, provided that you are not collecting money as part of that COD for old debt. But if it's just you're selling a dollar widget for $1 and it's COD, then you have very little, if any, preference exposure. Ordinary course business exception basically permits if you're always paid at 45 days, if you were paid within 45 days during the 90 days, that is a defense. What you typically see will be a slowdown in payments, 45 days the year before, then it'll go to 60, 65, and then maybe there'll be some payments made right before the bankruptcy, 3 or 4 days after an invoice. So you're going to be looking to what is the ordinary course of business between the parties, or what are ordinary business terms in the industry. That's a recent change to the code where it's an either-or test. Typically, however, we would focus on the ordinary course of business between the parties because that's fairly easy to establish based on the payment history. And last is
I would add that the ordinary course exception is more factual. You get into a new value exception is less subjective. It's a little easier to calculate and apply. Has a little more teeth to it because it's more objective than an ordinary course of business exception, and so it's easier to apply. Also, there are ways to apply these defenses that can maximize your protection in what you apply first, whether you apply due value or ordinary course first, and we usually get into that with the client when we know what the facts are.
Exactly, and slightly less common but it's picking up in light of the fact that a lot of the bankruptcy cases that are being filed now are resulting in very little money for creditors are fraudulent conveyance actions. And a fraudulent conveyance can be one of two. It can be an actual fraud or constructive fraud. And the look-back period for fraudulent transfers is much longer. It's 2 years under the bankruptcy code, but also if state law, for example, California law is 4 years, the trustee or the debtor in possession has the ability to look back as long as state law permits. So you could be looking at potential exposure for as far back as 6 years under certain states. Actual fraud, probably not that common. That's a transfer made with actual intent to hinder, delay, or defraud a creditor. For example, $1 million the day before your bankruptcy filing given to, or 2 years even before your bankruptcy filing given to a friend, so that money is now part of your estate. That would be a fairly typical actual fraud case. Those are much less common because of how challenging they are to assert, but it certainly is possible. What we see more frequently are the constructive fraud causes of action, and that's when a debtor receives less than reasonably equivalent value for what they paid. So if they paid $500,000 for a piece of equipment that's worth $250,000, that's a potential constructive fraud case. These are highly fact-intensive. Insolvency becomes important. What is the reasonably equivalent value? There's a number of factors that you get into. Again, these can be more challenging to both assert and defend because they're a lot more expensive. But we have seen more frequently trustees including 4-year transfers in their initial demand letters in a way to try to have more negotiating power on the fraudulent transfers, or on the preference.
Matt, well, I just wanted to add something on fraudulent transfers. It's surprising in some ways how these can arise. I was involved in Enron and had a few defendants, represented a few defendants for preference and fraudulent transfers, and the fraudulent transfer aspect was pretty darn unfair, I would say, to my clients, some of whom had millions of dollars of exposure, because Enron used a consolidated account to pay its vendors for all of its subs, and so I had clients that provided services to a subsidiary of Enron, which was also in bankruptcy, and unknown to the client, because of the cash management system put in place by Enron, the client would get checks for payment under its contract for services provided, and those checks would have the name of the subsidiary on them. However, the account was actually held by the parent, and so the parent was making payments for services provided to the subsidiary. Unfortunately, the case law on this is that your defense for this constructive fraudulent transfer, which is I gave reasonably equivalent value, in the instance I'm talking about, you're not giving the value directly to the party that's making the payment. However, indirect value counts, and so a lot of the cases that we saw in the Second Circuit in New York on this issue, however, required the subsidiary to be solvent in order for there to be an indirect benefit to the parent company that was making the payment for the services provided. If that subsidiary was insolvent, the cases indicated that it could very well be a constructive fraudulent transfer. And the unfairness in that is, you as a counterparty don't know who's actually cutting the check, and you have nothing to do with that, and it could potentially expose you to some risk in dealing with a party that goes into bankruptcy.
And there is one really important safe harbor, particularly that is relevant to the energy industry, which is 546E. This provides a safe harbor to any fraudulent transfer or preference actions other than actual fraud that could be brought by the trustee. And interestingly, this is typically found in the commodities cases for MF Global, Peregrine, cases like that. But there's some recent developments out of the Fifth Circuit that have applied the safe harbor to electricity requirement contracts. And there may be an ability for others to start building the 546 safe harbor into defenses to preference actions. So in order to qualify, you have to be a party to one of the parties must be a forward contract merchant. The transfer must be made in connection with a forward contract and must be considered a settlement payment. Some definitions of each of those for you, and here I will go forward just to talk briefly about the law. But as I said, in the Fifth Circuit recent decision, they held that there is really no distinction between a financial forward contract and a typical forward contract for electricity, for example, and that if the electricity contract, in this case, it was a 2-year contract to provide all electricity that was required. If it satisfies all of the other elements of 546E, which the Fifth Circuit found this contract did, the contract counterparty was entitled to the 546E safe harbor and did not have to repay, I believe, over $1 million that was paid to him within the preference period. So this is an important element. I mean, if you think about your power purchase agreements, you think about other types of contracts that are involved in the energy industry that could apply for the 546 safe harbor, and there's a lot of possible applications, particularly in light of this recent Fifth Circuit ruling. So I'm going to hand it over to... Oh, sorry, go ahead.
Well, just one other point on the 546E. 546E will protect you on preferences and constructive fraudulent transfers. It doesn't protect you on actual fraud. However, as Matt said earlier, those are rare cases. You need the Madoff Ponzi scheme to satisfy an actual fraud. So now we're turning to executory contracts. Professor Countryman came up with a definition years ago. That definition is widely used. There's another definition, but we're not going to really get into that. My personal definition is if the debtor is in a friendly forum and asks the judge to say that a contract is executory, the judge can probably find a way to rule that way in the debtor's favor. But generally speaking, executory contracts are contracts where the obligations of both the debtor and the counterparty are so far unperformed that the failure of either to complete that performance constitutes a material breach in excusing the other party from performance. We have some examples here of executory contracts. Executory contracts are important. I mean, we'll get into it a little bit more with the 363 sales in bankruptcy. I mean, these are assets or potentially assets of the debtor. So what can a debtor do with an executory contract? And this is within the debtor's business judgment as to what it thinks is what it assesses is best for the estate and to maximize value. It can assume the contract. If it decides to assume the contract, it must cure all amounts due under the contract and provide adequate assurance that it will perform going forward. The debtor can also assign the contract. The contract first has to be assumed, so the debtor has to satisfy the assumption requirements, but then can assign the contract to a third party, and that's typically how these contracts that are beneficial and add value, that's how they are transferred to a buyer under a 363 sale. In addition, the debtor must show that the assignee of the contract also provides adequate assurance of future performance under that contract. The assignment of the contract under bankruptcy law excuses the debtor from performance and liability. So there's an automatic novation under the code when it's assigned. Let's see, whether anti-assignment clauses are enforceable, right? So this area really deals with normal contracts. General contracts may have a provision in them that says both parties need to consent to any assignment of the contract. Under bankruptcy law, that's typically not enforceable. There are exceptions to that. The exceptions, if you think about it, generally revolve around, government contracts for one, intellectual property issues, because the Bankruptcy Code has specific provisions dealing with intellectual property. In particular, 365N deals with the rejection of intellectual property by a licensor or debtor. So if the debtor is the licensor of the intellectual property and decides to reject the license, the counterparty has certain rights to actually basically keep the license so long as it continues to pay, but still the licensor is let off of certain of its obligations under the license. And one sort of area that where anti-assignment clauses are enforceable are sort of contracts that require or are based upon personal services or the identity of the party. So franchises are an area where the franchise revolves around the franchisee's ability to meet the standards for the franchise. So partnership agreements, personal services contracts, even requirements contracts can have enforceable anti-assignment clauses, but by and large, they're generally not. And then the third alternative for the debtor is rejection. The debtor can simply take a contract and say, I reject. And that means that, and the bankruptcy court would have to approve it, just like it would have to approve assumption and assignment. Rejection is the debtor getting authority to breach the agreement. And when it does, your damages as the counterparty become unsecured claims. So if you have under a contract rights to payment and certain future profits built into the contract, upon rejection, you now have an unsecured claim based on the debtor's breach deemed to have arisen as of the petition date of the bankruptcy for those damages. If you're performing under your contract and during the bankruptcy, it really is the debtor doesn't necessarily have to perform under the contract, but the counterparty does. It doesn't sound fair. Your recourse really is if the burden for your performance is so high that or expensive or what have you, that you need certain assurances that the debtor is actually going to perform, you can move the bankruptcy court to compel the debtor to decide to assume or reject that agreement. The threshold on such a motion is pretty high. The Bankruptcy Code on general contracts allows the debtor to wait until confirmation of a plan to decide to assume or reject agreements. So this arguably would accelerate it. Now there is an exception. Real estate, I'm not talking about unexpired leases. Those have a different time frame attached to them, and you can see here on this particular slide with the exception, they have to be assumed or rejected within 120 days. The debtor can extend that time frame for an additional 90 days, but nothing further, no further extensions. The court is not allowed to authorize any further extensions without the landlord's written consent. Ipso facto clauses. So we touched on this briefly, where a clause says that the debtor's or that the party's bankruptcy filing, is an event of default. We call it an ipso facto clause because the Bankruptcy Code says, regardless of that provision, if the debtor in the bankruptcy decides to assume the contract, it can, and it does not need to cure It does not need to cure the bankruptcy default because it can't. It filed bankruptcy. That was it. Those ipso facto clauses also apply to defaults based upon the debtor's financial status and things along that line. So, you know, they're difficult to draft around if really what you're getting at is if my counterparty goes into bankruptcy, I don't want to do business with them. So the reference here to Section 365C1 is a reference to the portion of the bankruptcy code that provides that the debtor need not cure certain provisions. For example, the bankruptcy default provision. I'll turn it back to Matt for administrative claims.
Yeah, and I'll be brief so we can get into the 363 sales before we turn it over to the Q&A. But when you're dealing with a debtor after they've filed bankruptcy, typically you can continue to perform under your contract. The debtor has the ability to breach if they want. But if you're providing goods post-petition, you're going to have an administrative expense claim 9 times out of 10. You're entitled to an admin claim if you have if it's actual necessary costs and expenses of preserving the estate. So to the extent you're providing things necessary for the debtor's business, you would have an admin claim. The debtor's entitled to continue to pay you for all post-petition deliveries. They can't pay you for pre-petition goods during the case, but they can pay you for post-petition goods. So lots of times, use GM or any of these big entities as an example, it's really business as usual. There's just a portion of a receivable that would remain unpaid. The admin claims must be paid full in order to confirm a plan, so you have a lot of leverage. Typically, Chapter 11 cases are not administratively insolvent. Use a recent example of SACCON. That is a case that had a very quick trigger from the Chapter 11 to the Chapter 7. They were unable to quickly sell, so rather than run up a ton of admin fees in the 11, the secured creditor quickly pushed for a conversion to Chapter 7. At Chapter 7 trustee was appointed, and the assets were sold. So in that regard, I'm going to turn you over to Rich so he can talk a little bit more about sales and bankruptcy before we.
Okay, so sales and bankruptcy. Now one area where we see probably a potential for a number of sales coming up would relate to independent power plants and merchant power plants that supply the grid. The ones that don't have power purchase agreements in place. What we're noticing is that those plants that financed in 02, 03 to 07, 08 are probably coming up on their financing, and really until 07, 08 did we see the stabilization and reduction in the cost of natural gas as a fuel to fire up these plants, and so we see that a lot of these plants, their business plans that were created around and in support of borrowings back in that time frame are just out of whack, and they may have a lot of difficulty obtaining refinancing. In that event, we could see an increase in sales on those power plants. We also see, with the environmental issues, especially with coal, that there is a good force. Yeah, Matt, leave it on this slide. I'll get into this one. There is an impetus to convert those over. Coal, unfortunately, has a lot of environmental issues, and the bankruptcy might be a way to deal with, being able to sell the property and sort of control your exposure on environmental and labor and other types of issues. So we may see some activity and pickup in this area going forward. I just wanted Matt, turn it back to, I guess, slide 2 under the sales. Yeah. So what I just wanted to go through is sort of a typical marketing or a typical 363 sale process. Initially, the debtor markets its assets, and it usually does this before it even gets into bankruptcy. And it hires an investment bank normally. They solicit letters of intent from prospective buyers, and then the debtor probably selects a stalking horse. That stalking horse, that's a term that we refer to. It's the party that sort of sets the baseline for the terms of the sale and enters into an asset purchase agreement and likely requires the bankruptcy process in order to limit successor liability exposure and control the assets that are obtained. I mean, the best part about a sale in bankruptcy is that essentially you get the rights that you would get outside of bankruptcy in a stock purchase. However, it's structured as an asset sale, and so you're able to limit your exposure. And because the bankruptcy court has jurisdiction over the assets and the claims against those assets, it's able to deliver to you those assets free and clear of claims, interest, and encumbrances. So there is a huge benefit. And some of these sales happen pretty darn quick. If you look back at GM and Chrysler, you're talking days. A recent sale that we just represented a buyer on, the Dodgers, that took a while, but really the lead time was all the fighting that was occurring between Major League Baseball and McCourt to get to a sale process. But once it got to the sale process, it moved pretty normally. So getting into the sale process itself, again, the debtor markets the assets. It chooses, hopefully, it has a business that's in demand. So it looks at prospective buyers' letters of intent. It'll select a buyer. It'll negotiate an asset purchase agreement. The buyer can negotiate for certain deal protections, breakup fees, costs and expenses, overbids, timing of marketing, because we're not done with the process yet. In the normal course, because the debtor is a fiduciary and required to maximize value for the estate, typically an auction is then required. So now you have a buyer ready to go forward, but that sale process is subject to a further auction, and so the debtor files a motion to approve the sale and the bidding procedures. As far as bid protections go, I've always found that timing on the bid procedures, how much time does the debtor have to market, is one of the best protections for a stalking horse, more so than an extraordinary breakup fee. And courts look at that as well, and there has to be a very good justification in order to accelerate the timing. You're talking, the melting ice cube, and it really has to be an ice cube, out in the sun today type of thing, where it's dissipating pretty quickly to get the courts on board to approve an expedited marketing, and also other factors such as how much time and effort did the debtor spend marketing the assets pre-bankruptcy, and what's the like in GM and Chrysler, you only had a limited, and also I guess some of the financial institutions, you only have a limited number of potential buyers. So then the court approves the bid procedures.
Hey, Rich, I'm going to cut in here for a second. We're going to have to wrap up here, but I'm going to we've got the code we're at the hour mark, so I'm going to give the code for New York and the attorney affirmation form. The code is a 4-letter code. It's Q, S as in Sam, K, and then L. And so, again, that's Q, S, K, L. And so with that, we might want to just kind of pass through and finish. I know there's just really only one or two other items. We can just kind of hit that generally, but
yeah. Let me just okay. So then you go through the process. The court approves the sale. Once the court approves the sale, there's a stay, a 14-day stay. However, the court can waive that stay, and the bankruptcy code allows, once you close on the sale, if you're a buyer in good faith and satisfy that requirement, nobody, regardless if the order is overturned on appeal, nobody can undo the sale. So it moots out appeals and gives you finality pretty quickly in the process. But again, it requires the buyer to act in good faith. And one way a buyer doesn't act in good faith if it engages in collusion. Collusion specifically prohibited. So do not collude with other buyers or the debtor at any bankruptcy sale. And I'd just like to say the sales in bankruptcy have a lot more protections. They're a little more costly, but they have a lot more protections than alternatives, such as foreclosure, whether under the UCC, and then a public or private sale under those provisions. I don't know if we have time for the ABC section, but the materials are available. And if you have any questions on them, please feel free to reach out to any of us on the panel.
Yep, and so thanks, Rich. Thanks, Matt. I mean, on the last couple of slides that are on there on ABCs, we call it assignment for the benefit of creditors. That's just in some states they've got a process where you can buy